Hearing the appeal of Eco-Sud and two others against Ministry of Environment, Solid Waste and Climate Change and another.
Good morning. I apologise for the delay in starting. We have the benefit of technology, but it doesn't always work. I think we're there now. Thank you very much.
My lords, my lady, I hope that I can take the party's representation as read.
Please do.
In terms of sequence of submissions this morning, I will open the appeal on behalf of the appellants, the Minister and the Ministry, focusing on the core issue of statutory interpretation that arises on the appeal. Then Point and Destiny Lakeside Company, PDC, who support the appeal, will follow, with submissions addressing specifically the issue of the relevance or otherwise of parliamentary debates and the miscellaneous issues raised in Section 7 of Eco-Sud's written case, namely the so-called always speaking issue, if it arises at all on this appeal, and the relevance of international obligations and the Climate Change Act. Before I develop my submissions to the appeal, may I first take the board through the relevant statutory provisions? And I propose to do so in chronological order, broadly speaking, starting with the relevant provisions of the EPA itself, which was originally enacted with effect from 5th of September 2002. Then moving on to the provisions of the Environment and Land Use Appeal Tribunal Act of 2012, the so-called ELUAT Act, which came into force on the 1st of October 2012. And then finally, looking at the updated provisions of the EPA as they stood, both as at the date of Eco-Sud's filing of its appeal against the Minister's decision on the 28th of February 2011, and also as at the date of the first instance hearing before the tribunal on the 6th of October 2021, though I think it's common ground between the parties that it's the former date that matters for present purposes. So far as the EPA is concerned, the parties have referred in their written cases to the version to be found in the main combined appeal documents bundle. But the version published in the Government Gazette, which is in the supplemental bundle, contains a preamble to the Act, which I think is relied upon by Eco-Sud, and therefore I think it's probably more convenient to work from the gazetted version, which is in the supplemental bundle at starting at page 192. If I could please ask you to turn to that. Page 192, supplemental bundle, and you'll see that it's common ground that that came into force with effect from the 5th of September 2002. The Act deals with a broad range of matters that you can see from the arrangement of sections. If we go to page 195, you can see the long title or the preamble to the Act, which speaks for itself. And then you can see section 2, which is a declaration that every person in Mauritius has a duty to use his best endeavours to preserve and enhance the quality of life by caring responsibly for the natural environment of Mauritius. That's one of the sections that Eco-Sud relies upon in support of its case on construction. If you go to page 197...
will you be addressing us on the legal effect of that declaration?
Yes, I will.
Thank you.
Yes. Page 197.
I'm sorry, Mr. Tutor, I must be in the wrong bundle. Are we in the main hearing bundle?
It's supplementary bundle. First supplementary bundle.
Yes, the first supplementary bundle.
It's got 452 pages.
Right, I'm there now.
Thank you, my lord. And we were looking at page 195. If we go to page 197, just very briefly, you will see the definitions of EIA, EIA committee, EIA license, and further down the page, environmental impact assessment. Just some of the recurring terms that arise in the main operative sections further on. And if you go to page 200, you'll see definitions of proponent, essentially the promoter that carries out or proposes to carry out a particular project, or as it's referred to in the Act, an undertaking, and then public comment, which means a submission made under Section 20 by any person other than a public department or an EIA. And then over the page 201, the definition of tribunal. And I ask you to note at this point in time, so as at 2002, the tribunal is referred to as the Environment Appeal Tribunal, established under Section 53. And then a definition of undertaking on the same page. And then if we go very briefly through Section 5 on page 202, it provides for the establishment of a National Environment Commission. Over the page 203, the Act confers specific powers to the Minister for various purposes, as set out in Section 7. Page 204, Section 8 establishes a Department of Environment within the Ministry. And the department is to be administered by a director of the environment. On page 205, Section 9 speaks of the establishment of, effectively, an environment police. Section 10 of the establishment of a national network for sustainable development. And if we go to page 207, Section 12 speaks of the establishment of such technical advisory committee as the Minister might think fit to set up to advise him on the scientific and technical aspects of environmental protection and management. And then page 208 deals with the establishment of various enforcing agencies, Section 13, Section 14 on page 209 deals with the establishment of an Environment Coordination Committee. And then, if we go to page 211, Part 4 of the Act starts to deal with environmental impact assessment proper. And starting with Section 15, subject to Section 17, no person shall be required to provide a preliminary environmental report or an EIA in respect of any activity or project other than an undertaking. No proponent shall commence, proceed with, carry out, execute, or conduct, or cause to be commenced, proceeded with, carried out, executed, or conducted. I think we can skip to B over the page. Page 212, subsection B refers to an undertaking specified in Part B or C of the first schedule. So no proponent can effectively commence an undertaking which is specified in Part B or C of the first schedule without an EIA license. And if we can just jump forward to page 282 for what Part B of the first schedule shows, you will see that paragraph 22 of Part B on page 282 identifies a housing project and apartments above 50 units. There were later changes, as we'll see, to some of those provisions, but the core notion that you see identified here in section 15(2)(b) has essentially remained unchanged. So if we go back to page 212, to the main run of the operative sections, if we look at subsection 3, a proponent other than a proponent applying through the Board of Investment shall at least 3 months before submitting his application for an EIA license under section 18 provide the director with an outline of his proposed undertaking, including its location, nature, and scope. So at that point there was a 3-month time stipulation. One of the things that you will see when we look at a lot of the subsequent amendments to this piece of legislation is that there was an acceleration almost across the entire board of a lot of those time periods, which in my submission gives a sense of the pattern of legislative change after 2002, essentially trying to make the process more accelerated, take less time, and reduce delay. Then subsection 4, still on page 212, on the basis of the outline submitted, the director may impose the terms of reference for the EIA report, the fields of study that are required to be covered, and the levels of expertise and the qualifications of the consultant signing the report, and more provisions about what the director and what the proponent may be able to do in the rest of that section. And then we'll see in subsection 8, any proponent who contravenes subsection 2, in other words, who proceeds with an undertaking without seeking an EIA license, commits an offence. And I think I can skip forward then to the actual application process for an EIA license, which begins on page 215. A proponent, section 18.1, a proponent applying for an EIA license in respect of an undertaking specified in Part B and Part C of the first schedule shall submit to the director an EIA report as set out. If you go over the page 216, you will see what other materials have to accompany the EIA report in subsection C. Then in subsection 2, the EIA report shall contain a true and fair statement and description of the undertaking as proposed to be carried out by the proponent, and shall include the various matters that you see at the bottom of page 216, which include, for instance, at D, the precise location and surroundings of the undertaking, the zoning of the site, and the number of similar undertakings in the area. E, the principal concept and purpose of the undertaking. F, the direct or indirect effects that the undertaking is likely to have on the environment. G, an assessment of the social, economic, and cultural effects which the undertaking is likely to have on the people and society. And then over the page, 217, H, any actions or measures which the proponent proposes to take to avoid, prevent, change, mitigate, or remedy as far as possible the likely effects of the undertaking on the environment. I, an assessment of the inevitable adverse environmental effects that the undertaking is likely to have on the environment, people, and society, where it is implemented in the manner proposed by the proponent.
An environment includes all living organisms, I see, from
Yes.
197.
Yes. And then, for instance, K, any alternative manner or process in which the undertaking may be carried out so as to cause less harm to the environment. L, an environmental monitoring plan. N, in the case of a new infrastructure proposal, an environmental management plan to be implemented during the construction phase. And then O, such other information as may be necessary for a proper assessment and review of the potential impact of the undertaking on the environment, people, and society. And then if we go over the page 218, there are provisions for the involvement of specialist consultants in the EIA process, subsection 1 of section 19. And then importantly, at the bottom, in the second half of page 218, section 20, headed public comment, an EIA submitted under section 18 shall be open for public inspection during working hours at the various locations specified. And subsection 2, the director shall give notice of public inspection specified in subsection 1 in 2 issues of the Gazette and in 2 issues of 2 daily newspapers, there being in each case an interval of at least 7 days between the first and second publications. You see that over the page at 219. Subsection 3 states what the notice has to contain, which includes at sub D specification of the time limit for the submission of public comment in writing, which shall not be later than 28 days after the date of the first appearance of the notice in the Gazette. The director may, in respect of an EIA other than one submitted through the Board of Investment, extend the time limit specified in subsection 2 to afford reasonable opportunity for any person to submit public comments on the EIA, and the Director may also cause to be published an EIA or an extract of an EIA on the Internet for public inspection. There is then a detailed process of review of the EIA provided for in section 21, which involves the Director reviewing the EIA and referring the EIA together with any comments and observations as he thinks appropriate, together with any public comment submitted under section 20 to an EIA committee for examination not later than the stipulated period. And then over the page 220, the Director may, for the purpose of the review under the preceding subsection, request the participation of various public departments, enforcing agencies, non-governmental organizations, or indeed technical committees of one kind or another. If we then go over the page, 221, you can see some more information about the composition of the EIA committee, as well as the fact that there can be subcommittees also established for the purposes of examining particular projects.
Where does it say about the non-governmental organisations?
This is on page 220. At top of page 220, subsection 2A, the Director may, for the purposes of his review of an EIA, request any public department, an enforcing agency, any non-governmental organisation.
I see, but they're not part of the committee.
No. They're certainly not provided to be part of the EIA committee, but I don't, just thinking off the top of my head, I don't see why, looking at section 22, why, for instance, advice, for instance, might not be sought by an EIA committee or a subcommittee from specialists in the field who may happen to be from a non-governmental organisation. It's perfectly conceivable. I don't think that it's actually provided for in that way, but...
well, there's a power to co-opt in subsection 4.
Yes.
But the co-opted member has no voting rights.
But with no voting rights, yes. Yes. So there's some flexibility there, clearly. If you then go to page 222, section 23 deals with the actual decision that might result in relation to an EIA. Subsection 1, subject to subsections 3 and 4, the Minister shall, after taking into consideration the recommendations of the EIA committee, make his decision on the EIA within the periods identified. And subsection 2, the Minister may, subject to section 24, approve the issue, I think the word of is presumably missing, approve the issue of an EIA license on such terms and conditions as he may deem appropriate, or disapprove the EIA and reject the application. And then subsection 3 deals with where the Minister is unable to make a decision. He shall then refer the EIA to a technical advisory committee set up under section 12, etc.
But he could take into consideration a recommendation not to grant a licence and decide nevertheless to grant it.
Indeed. And that, for example, could be relevant in the context, for instance, that I'll come on to when I turn to my main submissions. That could potentially be relevant to the question of the legality, by public law standards, of the Minister's decision-making process, which may be something that is entirely separate, but nevertheless existing alongside the appellate jurisdiction of the tribunal. But I'll come back to that if I may. But Your Lordship, of course, is entirely right that this extensive consultation process depending upon how it is conducted, the consultation and the decision-making process, depending upon how it is conducted, may itself give rise to separate complaint of a public law nature, but which does not directly engage the appellate jurisdiction of the tribunal. But going forward to page 223, subsection 4, the Minister may, within 14 days of receipt of the advice of the Technical Advisory Committee, and in the light of that advice, approve the EIA subject to terms and conditions, or he may still disapprove of the EIA and reject the application, and then provision for notice to be given in the Gazette in subsection 5. Subsection 6, subject to an appeal under sections 56 and 57, the decision of the Minister shall be final and binding. And the Director shall comply and give effect to the decision of the Minister under subsection 2 or 4, and where an EIA is approved by the Minister, the Director shall issue an EIA license on the terms and conditions specified by the Minister. And then section 24 deals with what account must be taken of in considering approval of an EIA, and various matters are listed there. Go over the page 224. There are more provisions as to the deeming of conditions of the EIA license where the Minister is given directions. That's subsection 2. And then subsection 3, notwithstanding the approval of an EIA, the Minister may at any time A, revoke an EIA license or amend the conditions of an EIA license in the circumstances described, or B, give the proponent such directions as he considers necessary in relation to various aspects of the undertaking. And then over the page 225, section 25, the Minister may also at any time after the issue of an EIA license issue a direction to the licensee requiring him to submit a fresh EIA in respect of his undertaking within such time as may be specified. With regard to the reference to rights of appeal in sections 56 and 57, if we go forward to page 241, you will see that part 8 of the Act dealt with the Environment Appeal Tribunal. Section 53 on page 241 states, there is established for the purposes of this Act an Environment Appeal Tribunal, which shall consist of a chairman who shall be a barrister at law of not less than 10 years standing, appointed by the Public Service Commission, and B, such other members with at least 3 years' experience in a field related to the protection and management of the environment as may be appointed by the Attorney General. And then over the page, 242, section 54, you can see in subsection 2 above that the Attorney General plays a role in the appointment of members on an ad hoc basis in relation to the tribunal. And then the jurisdiction of the tribunal is addressed in section 54. The tribunal shall hear and determine appeals against any decision of the Minister on an EIA under section 23. So what you note immediately at this point is that 53(1)(a) Roman 1 dealt with any decision of the Minister on an EIA under section 23, and that could be a decision granting a license, or it could be a decision refusing a license, and there is then an enumeration of all those other things that a Minister potentially might decide in Roman 2 to Roman 6, which might also be the subject of challenge by way of appeal to the tribunal. And then importantly, over the page, 243, subsection 2 says, at the top of the page, any person may appeal within 30 days of the decision. Any person may appeal within 30 days of the decision, direction, order, or notice referred to in subsection 1, in such form and manner as may be prescribed by regulations. If you then go to page 244, Section 56 deals with, forgive me, you can see on page 243, Section 55 describes the proceedings of the tribunal, and a quick glance at Section 55 shows that it's essentially a sort of quasi-judicial procedure, including in relation to the receiving and taking of evidence. Then page 244, Section 56, determination of the tribunal. Subsection 1 deals with the constitution of the tribunal, including the handling of conflicts of interest. And subsection 2, the possibility of disagreement and majority rule in relation to the determination of the tribunal. And then at 245, subsection 3, subject to section 57, which deals with an appeal to the Supreme Court, as we'll see in a moment, a decision or finding of the tribunal on any cause or matter before it shall be final and binding on the parties. On hearing an appeal, the tribunal may confirm, amend, or cancel any decision, order, direction, or notice referred to in section 54. You can see the rest in subsections 5 to 7, including dealing with costs and so on. 57, at the bottom of the page, appeal to the Supreme Court. Any party who is dissatisfied with the final decision of the tribunal relating to an appeal under section 56 as being erroneous in point of law may appeal to the Supreme Court. And I think that's probably all I need to show you in relation to...
Where does it say the nature of the appellate, the intensity of review?
Yes.
Is it a JR type review or a full...
It's not specifically described,
right.
but I would suggest that in the light of the open wording of subsection 4 on page 245, that the appellate jurisdiction is essentially a jurisdiction to review the substance of what the minister has decided.
So it's a merits appeal?
It's a merits-based appeal, which would also explain, for instance, why the proceedings before the tribunal include the receipt of evidence as to the detail of the matters that are the subject of the decision.
And is that how it has in fact exercised its jurisdiction since 2002?
I can't tell you that as a matter of fact, but I apprehend that is how proceedings are conducted. Certainly, when you look at the pleadings in the case before tribunals, there are full-blown pleadings.
Well, it must publish its decisions.
And it publishes its decisions, and on the face of it, yes, it's a decision review on the merits, not a more technical public law review in the judicial review sense. I think I can stop here in relation to the original form of the EPA. And pausing here, I ask the court to take note of 4 key points in relation to the Act as originally promulgated. First, the original tribunal was established solely for the purposes of the EPA, and no doubt reflecting that, it was known as the Environment Appeal Tribunal. 2, any person had the right to appeal to the tribunal in respect of any decision of the minister in respect of an application for an EIA license, whether it was a decision to grant or a decision to reject such an application, and this right was exercisable within 30 days of the minister's decision. 3, an appellant could therefore include not only the proponent of the relevant undertaking, but also any member of the public or other person or organization, whether or not they had taken part in the consultation process preceding the minister's decision, and whether or not they would be personally prejudiced by the decision. The right of appeal was extended literally to any person, and no specific test of standing was prescribed as to who was entitled to appeal.
So any busybody could appeal?
Indeed. under that regime. And 4, there was a further right of appeal from the tribunal to the Supreme Court, but on points of law only. The next relevant legislative development is that important changes were made to the appeal regime by the terms of the Environment and Land Use Appeal Tribunal Act of 2012, the ELUAT Act, which came into force almost 10 years to the day since the original enactment of the EPA, with effect on the 1st of October 2012, which is and which effectively introduced the provisions that were legally effective as at the date of the minister's decision on the 31st of January 2019, and indeed as at the date of filing of Eco-Sud's appeal about a month later, in February 2019. And the version of the ELUAT Act I propose to look at is in the electronic bundle at page 1660. And you will see that it's proclaimed, at the top of the page, proclaimed with effect from the 1st of October 2012, which effectively therefore marks its commencement date. And bottom of the page, an act to provide for the establishment of an environment and land use appeal tribunal and for related matters. Page 1661, section 2 deals with interpretation. In this act, if you look at the definition of relevant act, the relevant act means a series of acts which include but are not limited to the EPA. There's a reference to the Building Act, the Local Government Act, the Morcellement Act, the Town and Country Planning Act, or such other acts as may be prescribed. There's a definition of the tribunal to mean the Environment and Land Use Appeal Tribunal established under Section 3.1. And Section 3.1 at the bottom of the page says, there is established for the purposes of this Act and the relevant acts a tribunal to be known as the Environment and Land Use Appeal Tribunal, which shall consist of, and then you can see over the page 1662, a chairperson who shall be a barrister of not less than 10 years standing appointed by the Public Service Commission, one or more vice chairpersons who shall be a barrister or barristers of not less than 5 years standing, again appointed by the Public Service Commission, and C, such other members as may be necessary to enable the tribunal to discharge its functions under this Act and the relevant acts, who are not public officers, members, chief executives or officers of a local authority, or members of or candidates for election to the Assembly or a local authority, or persons otherwise actively engaged in politics. And then subsection C deals with the appointment and remuneration of members appointed under the earlier subsections. Subsection 4 deals with where the subject matter of an appeal relates to a technical field, the Attorney General may, on the recommendation of the chairperson, enlist the services of a suitable expert in the field to act as member of the tribunal on an ad hoc basis for such period as he considers necessary. And then over the page, 1663, tribunal shall sit in one or more divisions, and then there are provisions about the composition of the divisions. And in subsection D, top of the page, any decision of a division of the tribunal shall be considered to be the decision of the tribunal. And then importantly, at the bottom of the page, jurisdiction of the tribunal. The tribunal shall hear and determine appeals under Section 54 of the EPA, as well as in respect of decisions under the various other relevant acts, one of which you can see in sub 2 at the bottom of page 1663, but you can see others at the top of page 1664, one of which I ask you to note because it becomes a little relevant later, subsection 3, decisions, for example, under section 7b of the Morcellement Act. And then subsection 2, at the top of page 1664, the chairperson, or in his absence, the vice chairperson, may, in respect of any matter which is due to be heard by the tribunal, on application made to him by a party, sit alone for the purpose of making such orders, including an order in the nature of an injunction, as he thinks fit, where he is of the opinion that for reasons of urgency and the likelihood of undue prejudice, it's necessary to do so pending the hearing of the matter. And then provisions about the proceedings of the tribunal, largely reflecting the substance of what had what had been set out in the earlier sections of the EPA that we looked at earlier, so sections 53 to 57. But this is effectively set out, as it were, again or afresh in relation to the newly established ELUAT. And then over the page, 1665, you can see the powers of the tribunal as regards making orders for the attendance of witnesses, the production of documents, and the taking of evidence. Subsection 7, the time period for the tribunal to make a determination. And then subsection 8, the tribunal may, upon consideration of the grounds of appeal set out in the notice of appeal and the objections made against the appeal, dismiss the appeal where it appears to the tribunal that it is trivial, frivolous, or vexatious. You may recall there was no such specific power of summary dismissal in the original appeal regime under sections 54 to 56 of the EPA. But by this act, a specific power was conferred upon the tribunal to dismiss trivial, frivolous, and vexatious appeals. And if we go over the page, 1666, there is provision in section 6 for an appeal to the Supreme Court on points of law. Any party who is dissatisfied with the final decision of the tribunal relating to an appeal in section 4 as being erroneous in point of law may appeal to the Supreme Court. And then importantly, section 8 at the very foot of page 1666 deals with consequential amendments. And those consequential amendments are then set out over the page, 1667, starting with subsection 1 of section 8, which concerns consequential amendments to the EPA. In section 3, the first amendment is by deleting the definition of tribunal. Secondly, by repealing Part 8 and repealing it in its entirety. So all of the sections that we saw from 53 to 57, at the very least, comprising Part 8 of the EPA, was repealed and replaced by what is then set out as new sections 53 onwards. The new 53 says, in this part, tribunal has the same meaning as in the ELUAT. 54, the tribunal shall hear and determine appeals against a decision of the minister under particular sections, as well as under, and these are effectively between sections between 16 to 25, and then two other groups of decisions under sections between 70 to 78. We can forget, for present purposes, about the group of sections referred to in B and C, because those essentially relate to the EPA enforcement regime, which is not presently engaged. So far as subsection A is concerned, essentially 23.2 deals with the minister's approval or rejection of the application for an EIA license. 23.4 likewise deals with the same subject. 24.3a deals with the revocation of an EIA license or amendment of the conditions of an EIA license. 24.3b deals with the giving of directions to a proponent, which become deemed conditions. And 25.1 deals with requiring a licensee to issue a fresh EIA report. So therefore, there's a variety of types of decision for which the tribunal is given jurisdiction to hear appeals about. And then importantly, the critical provision, which is at the heart of this appeal, subsection 2 says, where the minister has decided to issue an EIA license, any person who is aggrieved by the decision and is able to show that the decision is likely to cause him undue prejudice may appeal against the decision to the tribunal. I'm not going at this point to start on the detailed arguments of construction. I'm just at the moment showing you the provisions. I will come back to the points of detail shortly. But I ask you to note that these requirements that have been explicitly laid out in section 54.2 only apply where the minister has decided to issue an EIA license. Parliament has not seen fit to identify such requirements in the case of any other appeal, and I'll come on to the potential significance of that later. In addition to the appellate jurisdiction, and perhaps alongside it, you can see that subsection 3 says, any person who has suffered damage or prejudice as a result of a breach of an environmental law by another person may make a claim to the tribunal where the claim does not exceed 50,000 rupees. And that claim can lead to the tribunal making an award of damages against the person who has caused the damage or prejudice. I don't think it's fair to say that subsection 3 is not entirely clear as to whether the possibility of a claim only arises in the context of an appeal, in other words, as part of an appellate jurisdiction of the tribunal, or as part of an original jurisdiction to grant damages in respect of specific claims. What is clear, however, is that the tribunal does have jurisdiction, whether original or appellate in nature, to award damages.
How much is 50,000 rupees in dollars?
It's not a large amount of money. It's less than £1,000. It's
Right,
about £900.
Fairly token jurisdiction.
It's I dare say it's probably worth rather more than it is worth here, but it's still for Mauritius. It's still probably, I suspect, a relatively modest amount of money. So yeah. It's a modest addition, if one can.
Presumably, somebody who's suffered more than 50,000 rupees of damage can bring a claim in the ordinary court.
Absolutely. And you see that understanding on the part of Parliament on page 1668, which effectively, I think, puts a complainant who might wish to invoke that limited jurisdiction to award damages to an election as to whether it's worth doing so within the confines of proceedings before the tribunal. And you see that at the top of the page, the tribunal shall not hear and determine a complaint under this act unless the person making the complaint has voluntarily made a sworn statement that he has waived his right to initiate civil proceedings before any court in Mauritius in respect of the facts that form the subject matter of the complaint. And the waiver constitutes a bar to subsequent civil proceedings being initiated by the complainant before any court in Mauritius in respect of the subject matter of the complaint, and civil proceedings, however, does not include an application effectively for constitutional redress under Section 17. Now, there is an interesting little point, I suppose one might say, as to whether the concept of a complaint under this Act is limited to, as it were, a standalone claim for damages, albeit for the fairly limited amount, or whether it also includes an appeal before the tribunal. On my construction, it doesn't really matter either way, but I ask you to note this point because I can see that certainly this particular subsection is not crystal clear on the point. And then importantly, at the bottom of page 60...
So you say that what this means is that if you challenge the grant of an EIA and you lose, then you can't go to court and make a claim for damage arising from the implementation of the project under the EIA, or what?
Well, if the concept of a complaint under this Act is not limited to a claim under subsection 3 for damages, but applies to a complaint by way of appeal to the tribunal, the effect of the waiver requirement is that you can only exercise your right of appeal in return for providing a waiver. I.e., if you exercise your right of appeal on that construction, you then have to give up any other form of remedy that you might have in the civil courts, other than a claim for constitutional redress. That's certainly one potential construction of that part of the Act. But as I'll seek to show, ultimately, on my construction, this particular point is in a sense neutral, or it doesn't really bear on the correct understanding or interpretation of section 54(2). But I certainly understand why the board would certainly wish to know how this might interact with the appeal regime.
How does the word prejudice in 54(3)(a), what's the meaning of that, as opposed to damage? Who suffered damage or prejudice?
Yes. Well, I think prejudice could potentially be a little broader than damage. Damage tends to be purely financial in nature, but even damage can obviously take multiple forms. I think it's a case of belt and braces on the part of the drafter.
Rather like expression loss or damage.
An example would be loss or damage. I think perhaps what is determinative in this context as to the intended meaning is that the purpose of that jurisdiction ultimately is to lead, if the claim is made out, to an award of damages. So that therefore, whatever the damage or prejudice might be, it is certainly contemplated to be of a form which a quasi-judicial body would consider to be properly compensatable by an award of damages. Beyond that, I wouldn't necessarily wish to provide an exhaustive list of all forms of damage or prejudice that might fall within the expression suffer damage or prejudice.
The tribunal doesn't have a power to injunct behaviour, does it?
It does.
Oh, it does?
It does. We saw that earlier. On page 1664, top of the page, subsection 2, in cases of urgency and where there is a likelihood of undue prejudice, the tribunal the chairperson, who may be sitting alone for that purpose, can make an injunctive order.
Yes, but not a kind of final injunction.
No, it's not. No, not a final. No, not a final. That is true. I was on page 1668, and I was going to show you subsection 3, which is of some significance in my submission. So this is dealing with the consequential amendments to the Morcellement Act. And in relation to appeals to the tribunal, it is said that any person aggrieved by a decision of the minister or of the board, as the case may be, granting or refusing to issue a letter of intent or a Morcellement permit, may appeal against the decision to the tribunal. So you'll note...
Morcellement, does that mean division of land?
Yes.
Something like that?
Yes,
yep.
Exactly. And so there is pointedly here in my submission no reference to any additional requirement over and above the need for the person to be aggrieved for that person to be likely to be caused undue prejudice by the relevant decision.
But who other than the owners of the land would have an interest in the division of land?
Well, it could be said, obviously, the owner of the land, but it could be neighbours, it could be commercial establishments in the area, it could be a whole range of potential stakeholders who may or may not be affected. I think it would be
They might be affected if there's subsequently going to be development of one of the fragments, but that would presumably need extra permission. wouldn't it?
Well, I think you're making assumptions as to what the provisions of the Marcelma Act may be. I'm not...
Well, I'm wondering if you're making assumptions about what the provisions...
Well, no, I'm not. I am not making any... For my purposes, I'm simply asking you to note that there was a particular parliamentary choice in the case of the Marcelma Act only to require that a person be aggrieved by the decision. There was no requirement.
Yeah.
But where does
I don't go be...
But where does that take you? Unless we understand the scope of the Morsemont Act, we can make no conclusion whatsoever.
Well, I think that there may be some limited conclusion one might be able to draw from it. But I will, if I may, I'll come on to that in a moment when I make my main submissions, because obviously that is the more sensitive or contentious area of the appeal. So I just wanted to show your lordships those provisions.
Before we leave those provisions, the Planning and Development Act 2004 was also amended by the repeal of Part 10 of that Act, and it was replaced by one section on 1669, which states the jurisdiction of the tribunal, and seems to impose no criterion of standing whatsoever. Is that right?
Yes, it looks that way.
Because Part 10 is repealed, and Part 10 included, I think, Section 57, which set out the provisions relating to an appeal to the tribunal.
I suppose we'd have to look and see who could bring an appeal to the tribunal under that Act, would we?
The trouble is the provisions have gone. But I'd be interested to know what are the grounds of standing under the Planning and Development Act 2004 as amended.
Yes. Well, I'm afraid I don't know the answer off the top of my head, but perhaps we can reflect on that and come back to
Thank you.
To the board. The next provision that I should briefly address, although it's less relevant because of the date from which it was effective, is the amendment that was made with effect from the 7th of August 2020, which we can pick up really quite shortly on page, in the updated version of the EPA, which begins on page 1576. Well, picking it up in the originating act itself, the Finance Miscellaneous Provisions Act of 2020 at page 1576. And section 18 in particular appearing on page 1578. Provides that the Environment Protection Act is amended as set out on page 1579, and you can see in subsection A, it stated that in section 54.2, by inserting after paragraph B, the following new paragraph, and you can see what is set out there, namely that the person in question, the would-be appellant, must have submitted a statement of concern in response to a notice published under section 20. Now, on its face, this was a further tightening of the preconditions to the right of appeal. And although it's not directly relevant because of the date of its effectiveness, in terms of the overall pattern of the changes to the EPA, it's of some note, because a person who is both aggrieved and unduly prejudiced by the minister's decision under subsections A and B is nevertheless not entitled to pursue an appeal unless they have submitted a statement of concern in response to a notice published by the Director of Environment under section 20.
Do you say we can take this into account in construing the other provisions, or not? On the face of it, not, because it didn't exist when they were...
no is the short answer. I accept that. Then
we can put it aside.
I will therefore skip to the next point, which is this, that a critical aspect of all of the statutory provisions that we have just seen is that they are focused on the jurisdiction of the tribunal to handle appeals on the merits against the minister's decision to issue an EIA license under the specialist appellate framework created by the Eluat Act and inserted into the EPA. Neither the EPA nor the Eluat Act addresses nor seeks to limit resort to the ordinary public law remedy of judicial review of the minister's decision where the circumstances for such review may be thought to exist by any person who may have a sufficient interest in the subject matter of the minister's decision.
Well, doesn't that depend on what the waiver that you showed us before covers, or is judicial review not count as civil proceedings?
In my submission it does, but the point I am making is that if a person has a right of appeal or is entitled to appeal, it can elect to go down the appeal route, but the quid pro quo for that is that it has to accept to waive resort to any other civil proceedings other than a claim for constitutional redress. But on the other hand, if it doesn't choose to exercise a right of appeal that it might otherwise have, or if it doesn't have a right of appeal,
so Mauritius doesn't have a rule of the kind that we have, that you can't go by way of judicial review if there's a statutory remedy available?
It does. So you're right that I need to qualify the latter part of my answer, which is this, that if a person with a sufficient interest is nevertheless unable to bring himself within the standing under the requirements of standing under section 54(2), if it is unable to bring itself within those requirements, it has no right of appeal, and therefore it would not have an alternative remedy open to it under the statute. In that event, obviously subject to any other conceivable remedy that that person may have, if there are no others, and it doesn't have the statutory right of appeal, then it ought to be entitled, if it has a sufficient interest, to bring a claim for judicial review. And the Act does not seek to prevent that. It leaves that in that area of the law entirely untouched.
If somebody tried to bring a judicial review proceeding, would it be open to the person who granted the director or the committee, or I don't know who the respondent would be, to say, no, you cannot go by way of judicial review, you must go by way of your appeal under section 54?
Well, of course, that argument could be raised. Whether or not it's correct will depend upon whether that person satisfies the requirements of standing.
Well, yes, well, I can see that, but, yes. But your point doesn't go very far. All you're saying is if someone hasn't got standing under the Act, they have a right to make a claim against a public authority by judicial review, but they would have no appeal on the merits.
That is correct. That is correct. I'll come back to the potential significance of that, if I may, but I'm simply asking you to note that the Act is entirely silent as to that area of potential redress. So if I can turn, therefore, to my main submissions, if I may, on the proper interpretation of section 54(2), I basically have 10 points or 10 areas I want to cover. First, at the risk of sounding trite, the board needs to interpret section 54(2) in accordance with well-established principles of statutory interpretation. These are to be found, at least partly, in the Interpretation and General Clauses Act of 1974, and we can take that very briefly because I'm sure the board has come across it before, but it's page 1763 of the bundle, if you look at page 1765, you will see that section 2 says, unless the context otherwise requires or unless otherwise expressly provided in this Act and in every other enactment and public document. And if we go to page 1769, you will see that person and words applied to a person or individual shall apply to and include a group of persons, whether corporate or unincorporate. And if we then go to page 1773, you will see that starting on 1772, forgive me, section 5 sets out general rules of interpretation, and over the page 1773, subsection 8, effect shall be given to each enactment according to its true intent, meaning, and spirit. Now, to a lawyer, of course, section 558 is a statement of the obvious, but it is rather lacking in detail. But additional guidance, however, can be obtained from decisions such as the Supreme Court's decision in the on the application of O against Secretary of State for Home Department case, which you will find in this second updated supplemental bundle starting on page 104, and if you could please go to pages 114 to 115. Again, I'll take that very briefly because...
Three of this panel, I think, are very familiar with the decision.
I'm half embarrassed about citing it, but if I could simply ask...
I don't think I've ever seen it before.
I'm very grateful.
I can look at it in my own time, don't worry.
In short, it emphasizes the obvious principle that interpretation is an objective exercise conducted by reference to the ordinary and natural meaning of the words in their proper context, in the context of the statute as a whole. So the true meaning and intent of section 54.2 is to be ascertained by reference to the objective meaning of the words that have been used, properly understood in the context of the EPA and the ELUAT Act as a whole. And the context of the ELUAT Act is
right. So it's basically it's the same principles as we apply here, is it, of interpretation? Is what this says. Yeah,
effectively, yes. And there are multiple examples in Mauritian cases where that process is engaged in.
Sorry, can I just be clear? What authority have we got that the same principles that apply in English law to statutory interpretation apply in Mauritius? Have we got? Is that what you were answering?
I don't think that principle, that proposition is in dispute between us.
Well, I was just taking the page you referred us to is citing Spath Home and...
Yes, but if I can take, for example...
This case is a UKSC case.
Oh, right, it is. I'm sorry, I thought you were taking us to...
No.
I thought you were showing us Mauritius jurisprudence on it. That's why I said I hadn't seen it before. Of course, I'm aware of these principles.
It has not been very easy to find a Mauritian authority that sets out the principles very neatly. But what you do find when you look at all the cases is the exercise that they engage in is the exercise that the English case law indicates. As an example, there are, for example, a lot of tax cases where you can see all the statutes being construed. As an example, if I can ask you, and again, you can look at it in your own time, I don't think we need to look at it now, it deals with the relevance of parliamentary debate specifically, but it also proceeds to, it's a Privy Council decision that analyses tax legislation in Mauritius, and it's the Chettiar decision, and it's in the second supplemental bundle, and you will see how they construe in accordance with the ordinary meaning of the words,
But I think you were saying it's not in dispute that the same principles apply.
Yes, that's my understanding. I haven't read anything in the other side's submissions suggesting, for example, that English-style, Westminster-style statutes are to be construed in accordance with French law. Obviously, in Mauritius, the civil code
Yeah.
is construed in accordance with French jurisprudence, but statutes almost invariably are construed in the English style by reference to English principles of construction. There are a lot of Mauritian lawyers in this room. If anybody disagrees with what I'm saying, I'm sure there'll be howls of protest.
Well,
but
that is my understanding.
I'm grateful, and Your Lordship
We look to French law for interpreting the civil code. For statute, we look to English law.
Yes, we will redouble efforts to find perhaps a pithier Mauritian authority that confirms this approach. Thank you. I'm very grateful. I'm very grateful. I'm very grateful to Mr. Durand de Speville. And if you look at page 2237, this is a decision. Perhaps I'll give you the reference. We don't necessarily need to dwell on it now, but it's the DSA company case, starting on page 2224, the passage at paragraph 14 onwards, starting on page 2237, extending to 2238.
That's where you look to Benyon, where the court has looked to Benyon, yes.
Yes. So, my Lord, my Lords and my Lady, if the objective meaning of the words is clear and unambiguous and does not produce absurdity, there is no necessity to have recourse to external aids to interpretation, let alone recourse to the subjective intentions of the minister or other promoters of the bill. But Mr. Durand de Speville will deal in more detail with the relevance of parliamentary debates. The second point I want to make is this, that applying these principles of statutory interpretation, we respectfully submit that the objective meaning of section 54(2), as inserted by section 8 of the 2012 Act, is crystal clear, namely, where the minister has decided to issue an EIA license, only a person who is both aggrieved by the decision and is able to show that the decision is likely to cause him undue prejudice is entitled to appeal against the decision. On their ordinary, natural, and objective meaning, these words mean that a putative appellant must be both aggrieved by the decision and able to demonstrate that the decision is likely to cause personal undue prejudice to him.
Where do you get personal from?
I get personal from him, cause him. If it were simply likely to cause undue prejudice, it would then obviously be a reference to anybody, prejudice to anyone. But it's cause him. And there is a very close analogy in this respect with the language that we will see in the context of the Constitution, Section 17 of the Constitution, where the language is contravention in relation to him, where the courts, including the board, have given effect to that specific reference to him in the statutory word.
Yes, I can see the force of that, but what do you mean by prejudice in this context, or what do you submit?
Yes,
prejudice?
Can I come back to that, if I may?
Well, it's the key point of the.
Yes, of course it is. But I'm conscious I'm running out. I'm running a little bit low on time.
Well, I'll let you continue.
But I will. Obviously, this is a key point. But if I may, I'll address it in the order of my submissions. And we say the language of cause him is an unmistakable objective indication that Parliament requires proof of likely undue prejudice to the putative appellant himself. And we say that this indication is reinforced by the requirement that it is the appellant who bears the burden of proving, must be able to show such likely undue prejudice to him. As I say, I'll come soon to the separate question of what precisely is to be understood by the notion of undue prejudice to the would-be appellant.
But you accept that any person, because you've taken us to the general provision, includes organisations, whether legal persons or natural persons.
I do accept that, and I'll come on to the relevance of that.
Unincorporated associations can suffer prejudice.
I accept that in principle, yes.
Yeah, well, that does point to a wide interpretation of prejudice. Anyway.
But I'll come on to that if I may. The third point I make is this, that the plain and obvious objective meaning of the words in section 54.2, and in particular the necessity to give distinct effect to the words of subsection B, is reinforced by several contextual factors. The first is that the right of appeal where the minister has refused to issue an EIA license is not made explicitly subject to any preconditions. But nevertheless, Parliament has gone out of its way to articulate explicitly the preconditions to an appellant standing where the minister has decided to issue an EIA license. Secondly, the express articulation of the requirements in subsections A and B.
So do you say then that if the minister refuses to issue a license, somebody other than the applicant can appeal against that decision?
No. One can quite understand. I don't suggest that it is necessarily surprising that Parliament has not addressed the question of the proponent's right of appeal, because of course in a case where there is a decision to refuse an EIA license, because self-evidently, as you say, as you imply, if there is a refusal, it would be the only realistic appellant is the proponent.
So I mean, that contextual point really carries no weight, because the only person who would have an interest would be the proponent.
That point doesn't carry any weight, but what does carry weight is the fact that Parliament has gone out of its way in 54.2 to make very clear that where there is a where there is a grant of an EIA license, only a person aggrieved and who is likely to be unduly prejudiced is entitled to appeal.
There's no doubt that the conditions are cumulative, and therefore it's not just a person aggrieved, it's a person aggrieved and the provision you're founding on.
Yes.
I don't think that's the question.
Exactly. And of course, the real question is, well, what do the conditions mean? That I accept. But nevertheless, I do say that the court ought to bear in mind the deliberateness of Parliament's choice in identifying and enumerating both conditions, not merely a requirement that the appellant or would-be appellant should be aggrieved. In other words, we say that the addition of subsection B shows that the legislative intention was that something substantially more than merely being aggrieved by the minister's decision would have to be shown by an appellant. Further still, Parliament has expressly given any person, including any member of the public or any organisation other than a public department, standing to participate in the broad consultation process preceding any ministerial decision. The court will recall the definition and language of public comments in sections 3, 20 and 21 of the EPA. Despite consciously permitting any such person to participate in the consultation process, Parliament nevertheless chose to restrict the right of appeal where the minister had decided to issue an EIA license to a much narrower class of persons satisfying the requirements of section 54.2.
So any busybody can participate in the consultation process,
Indeed.
But they can't then appeal.
It could be any busybody, or it could be anybody who has some interest but actually will not necessarily be directly prejudiced by the decision.
Well, it's any person.
Yes, indeed, it's any person. And so it's a short point. Again, of course, as always with debates about construction, the weight that one attaches to all of those indicia is a matter of very personal, subjective evaluation. And I'm simply identifying the indicia that hopefully...
Oh, no, you're absolutely right. When you look at the words used, you look at the statutory context in order to get a rounded view of what the provision means.
Yes, and the short point I'm making is that had it been intended that any member of the public or any organisation that was sufficiently interested to participate, to want to participate in the consultation process, that such a person should have a right of appeal, given the existing framework of participation of such a person in that process.
I don't think there can be any doubt about the intention to limit the people, but what I will be interested in when you get to the appropriate point is who you say can appeal,
Yes.
where it's, say, a wilderness that's affected and nobody lives right by it or has some financial interest in the outcome.
Yes.
Who
So
can appeal in that situation?
Indeed.
But we'll be coming to that.
I'll come on to that under my
Better
fourth
let you
heading.
press on, because I see
Yes,
time is
indeed.
getting on.
The further contextual factor I rely on is that the general test of a sufficient interest under Order 53 of the old English rules of the Supreme Court, as it applies to applications for judicial review in Mauritius, and Eco-Sud have identified the history of judicial review in Mauritius going as far back as 1992. That case law, that jurisprudence is well established under Mauritian law and must be taken to have been known to Parliament when Section 8 of the Eluat Act was enacted. Yet Parliament's choice was not to adopt the well-known flexible test of sufficient interest as the test of standing under Section 54.2. Instead, it chose the words that we are aware of. The fourth area is this. There is a suggestion that our interpretation leads to impractical or absurd consequences in circumstances where there is no natural person that would be personally prejudiced by the minister's decision, such as where the undertaking is proposed in the midst of an unpopulated wilderness. There are two answers to this point. The first is, it's not our case that only a natural person can meet the requirements of Section 54.2. We acknowledge that a legal person may also be capable, in an appropriate case, to show that it would be likely to be caused undue prejudice by the minister's decision. For example, a fishing company that whose fishing activities might be adversely affected by lagoon works in front of a hotel. One could no doubt imagine a whole lot of other examples. And I'll return to this aspect.
Well, are they all economic? Because it seems perverse that in legislation where it's seeking to protect the environment, only economic interests should count.
I don't suggest that. What I'll suggest in a moment, as I develop the argument, is that the concept of undue prejudice to the appellant is a reference to the prejudice to the prejudice of or prejudice to the appellant's personal interests, personal private interests. In other words, it's damage or prejudice to your own interests as opposed to the interests of a representative nature that you may have. That's the key.
We'll let you develop the argument, but give yourself time because we will be questioning you about that.
I am sure there will be. So let me come on to that if I may. But going back to the unpopulated wilderness example. So the first point is we don't suggest only a human being, as it were.
Well, this goes right to the point. This example. So your first, so far as I understand it, you so far said that people other than natural persons can appeal, but the only example you've given is a fishing company, so its interest would be economic rather than environmental protection.
And it would be economic in the context that they would at least temporarily be populating the lagoon with their activity.
But the second point, if I may make it, perhaps is the more relevant answer in terms of the apparent lacuna that effectively Eco-Sud is relying upon. We said the simple answer to the example of unpopulated wilderness is that a person with a sufficient interest within the meaning of RSC Order 53, even if not a neighbour or personally affected by the proposed project, may be entitled, in an appropriate case, to apply to the Supreme Court for judicial review of the minister's decision.
So your case is that purely environmental interests cannot be pursued on appeal. The appeal is only concerned with economic interests.
Not when Parliament...
And you have to go to the JR, otherwise, if you want to say something about its effect on the environment.
Yes, in circumstances where Parliament has taken care to delineate the jurisdiction of a specialist appellate tribunal whose existence and whose role is intended, save where a right of appeal exists and has been exercised, exists entirely alongside and without prejudice to the judicial review jurisdiction.
But don't you have to look at the broader purpose of this legislation and why you have an environmental impact assessment and what it's seeking to do?
Well, of course, but merely, that in a sense is merely restating the problem.
You're looking at context, and the context includes Section 2, and now it's an aspirational provision which may not be black letter law, but nevertheless, Section 2 is telling the people of Mauritius that everyone has to take an interest in their environment. So I don't see how you can list contextual matters without listing Section 2.
Well, let me come on to Section 2, if I may. I think I will address all of the points.
But anyway, I'm acutely aware of the time, so we'll try not to interrupt you.
Not at all. So the fifth point I want to make is this, that there's no real engagement by Eco-Sud in its written submissions with the application of the well-established principles of statutory interpretation. Instead, what you find, and it's very telling how they frame the argument at paragraph 6.4 of their written case. If you look at that, this is page 1537 of the bundle. The key submission that they advance is what is said at 6.4. But what we say is to be found there, essentially, is a bare assertion. It's a bare assertion of what Eco-Sud claims to be the purpose of Section 54.2, namely a single purpose, which is to distinguish between persons with an interest in the decision to grant an EIA license, which is sufficient to justify them being able to appeal against the decision to the tribunal, and those lacking such an interest. There's no real attempt to justify this assertion by reference to the meaning of the words used, or even the overall context of the Eluat Act. The assertion, we say, is in the nature of a bootstrap argument. It assumes the truth of what it seeks to prove. And by this sleight of hand, Eco-Sud effectively seeks to reduce the twin requirements of being aggrieved and likely to be unduly prejudiced by the minister's decision to a mere test of sufficiency of interest, akin to the judicial review standing test. And all of the argument that follows in the written case starts from that premise as to what they say the single purpose is, and they argue effectively in that way back to front. And we say there's no proper basis for reading down Section 54.2 in this way, and in particular for reducing a requirement of proof of undue prejudice to the appellant to one of sufficiency of interest. To do so is fundamentally inconsistent with the principle of construing the statutory words in accordance with their objective, ordinary, natural meaning, and having regard to the overall context in which they appear.
Can I just ask you this? On your interpretation, what does 54.2a add to 54.2b? How could a person who was unduly prejudiced not also be an aggrieved person?
Well, I suppose it's conceivable that I agree with you that it is quite hard to imagine, because one would think that if you are unduly prejudiced personally by the decision, you would feel aggrieved about it. It's conceivable, I suppose, that someone who's prejudiced by a decision isn't bothered about it, in which case then it wouldn't appeal. It wouldn't appeal, but it would at least have So I agree.
Is it a subjective test, aggrieved? Does it depend on the strength of your feeling, or is it an objective? Or what does it mean? It would be helpful to know your interpretation of that.
I think aggrieved is, I think, clearly a reference to a genuine sense of grievance by reference to the position that you occupy in relation to the proposed undertaking, and in the light of potentially how the decision might affect you. But I accept that the concept of grievance has been interpreted very broadly, and I don't seek in any way to challenge any of the decisions.
No,
I accept that.
Your point is that Walton and such cases can apply to the concept of a person aggrieved.
Yes.
Sufficient interest. What you say is we have to give due weight to the addition of B.
Yes. And really that's what it boils down to. And I'm not trying to, as it were, overturn decades worth of case law in relation to the liberal test that's been developed at common law in the context
yes,
of
I think what I'm
review.
putting to you is the drafting is problematic in any event, because it seems to me B automatically subsumes A, and therefore one can't apply what you might say a literal interpretation might be. One's got to go back to the underlying purpose. So even on your interpretation, you can't just say they're two cumulative requirements, because plainly B subsumes A.
Well, B may be stronger than A in some cases, but A may nevertheless potentially fulfill a role of its own. It may have been conceived of, I suppose, particularly when you consider legislation that refers only to being aggrieved, but doesn't necessarily go on to require, in addition, personal prejudice. You can see how the drafter, as a matter of drafting technique, may have wanted to simply adopt the A, as it were, as a more standard or a more commonly recurring test, but then want something extra to add to it. Yes, it may be that in doing so, the extra is actually so powerful that actually what's already there, what's often there, has a bit of a redundant role. But
you say it supports your point that it prevents you reading down B so that it means no more than A.
Exactly. So I think you've put it better than I have so far, that Lord Burroughs' consideration is in fact a consideration in my favour as to the all-importance of B relative to A, and therefore you can't say that's certainly not a powerful reason for not reading it down. But can I move on to my sixth point, which is that the UK Supreme Court decisions in AXA and Walton, and indeed the board's very recent decision in Mussington, we say are all distinguishable from the present case. No doubt Mr. Tromans will take you to those in more detail, but in short, we say, AXA and Mussington were decisions relating to applications for judicial review, where what was essentially an issue was the sufficiency of the interest of the applicants for judicial review. That's the particular context in which the relevant statements are to be understood. And I'm not going to take you to the relevant passages because I'm running out of time and you know them very well. Yes. But an important consideration in the context of judicial review, which provides context for the court's approach to the content of the test of sufficiency of interest, is that judicial review is concerned with the rule of law and holding the exercise of executive power to account. It's very important, it's perfectly understandable in that context, therefore, that the role played by personal rights or personal prejudice is much less than the role played by interests, including public interests. And that's a very important contextual point that we say.
But Walton Stall, the Walton case, Scottish Minister's case, wasn't about judicial review.
Well, Walton is a curious case in the sense that, and again, I won't take you to it, but I've referred to the relevant passages in my written case. Walton was a case where what was an issue was a statutory form of challenge. But it was a statutory form of challenge. It was very much like an application for judicial review because it was a form of challenge. And if you look at paragraph 9 of Walton, you will see two things. One is that the standing test depended upon whether there was an aggrieved person. There was no requirement for substantial prejudice. The question of prejudice was only material at the remedy stage in terms of whether there's a quashing or some other form of remedy that's granted. You'll see that very clearly in the extract of the legislation at paragraph 9 of Walton, number one. Number two, if you look at the nature of the challenge in that case, it was a challenge to the legality of the scheme in the light of the Act. It was very, very similar to a judicial review type challenge. And it was in that context that, not unnaturally in my submission, the Supreme Court assimilated the test of standing in that case, even though it was a statutory challenge rather than common law supervisory review. It assimilated the statutory test to the test of sufficiency of interest at common law.
Yes, I mean, you can make the point that the Court of Appeal may have erred in thinking Walton gave the answer.
Clearly, the Court of Appeal, yes, went too far in any event, and so, which is why it was obiter. But of course, I'm not relying on the fact that Walton was obiter on that point. I accept it.
I mean, your point is under the relevant statutory provision in Schedule 2 of the 1984 Act, what the person had to be aggrieved about was whether the decision was within the power of the Act or whether there had been a procedural irregularity,
yes.
Standard judicial review
Yes.
grounds.
Yes.
Yes.
So we say, in contrast with AXA, Walton and Mussington, what is an issue in the present case is not the scope of the court's supervisory jurisdiction over the minister's exercise of his statutory powers and the sufficiency of Eco-Sud's interest in invoking that jurisdiction, effectively to preserve the rule of law. Rather, what is an issue in this case is the scope of the tribunal's specialist appellate jurisdiction in the particular situation described in section 54(2), where the minister has issued an EIA license, and where such appellate jurisdiction exists additionally and without prejudice to the Supreme Court's judicial review jurisdiction over the minister. And so we say the key issue in this case is primarily one of statutory interpretation, because the jurisdiction of the tribunal and the extent of rights of appeal to it are entirely the creature of statute, rather than common law-based and dependent upon common law trends in environmental law. And it is solely about Parliament's will, not about following common law trends. And of course I accept that it is not difficult to conceive of an appellate jurisdiction that could be much more generous, much broader than was actually the case. Nobody's suggesting that. I mean, of course, if I or somebody else in this room were the drafter of the legislation, no doubt we could have thought, well, it would be a jolly good idea if the tribunal's appellate jurisdiction was as broad as possible.
I would hesitate to interrupt, but I'm fascinated by what your answer about the definition of prejudice is.
Yes, I'm so sorry. I keep...
Does it sound in damages at all? Or is it a different concept?
Yes. So the seventh...
do proceed and come.
The seventh point I want to make is this, that in contrast with the case law on judicial review standing, we say a more closely analogous line of cases, for present purposes, are the cases on constitutional redress, which also turn on the particular features of the relevant statutory wording. Section 17(1) of the Constitution imposes a clear requirement that an action for constitutional redress is only available where a person alleges that any of sections 3 to 16, which contain the fundamental freedoms and rights, has been or is likely to be contravened in relation to him. And it's common ground.
So that's like a victim test.
Yes. The contravention must be in relation to the complainant. And you see that at page 1643, very briefly, of the bundle. It's common ground that in such cases, both the Board and the Mauritian Supreme Court have consistently held that Section 17(1) provides a personal remedy in respect of personal prejudice. as is made clear by the phrase "in relation to him." And we see that in the Merbel decision, which went to the Privy Council. If you look at page 2353, and paragraph 26 at 2360, we'll see what Lord Phillips says in relation to that, paragraph 26. And we say there is a close parallel between the language of "in relation to him" in section 17(1) of the Constitution and the language of "the decision is likely to cause him undue prejudice" in section 54(2). And contrary to what Eco-Sud says, we don't accept the proposition that the reference to him in section 54(2) is a flimsy foundation for the proposition that personal undue prejudice is required. We say it's the only correct conclusion that can be arrived at on a conventional interpretation of the wording and subsection B as a whole. Now, the eighth point is this, that Eco-Sud contends that the purpose of section 54(2) is to oust busybodies and nothing more. But they only arrive at this conclusion by relying on what we say are selective and inadmissible extracts from the parliamentary debates. That's the only way in which they arrive at that conclusion. Mr. Dauger de Spéville will address the relevance and context of those debates in more detail, but for our purposes, I ask your lordship and your ladyship to note the following. On its plain and objective meaning, the language of subsections A and B is clearly not concerned merely with whether the appellant is a busybody. It requires both that the appellant be aggrieved by the decision and that it can show that it's likely to be unduly prejudiced by the decision. 2, if Parliament's intention had been only to differentiate between persons who were genuinely aggrieved by the minister's decision and mere busybodies, it's difficult to see why subsection A was not sufficient for this limited purpose. It clearly would have been in the light of the reasoning in Walton, and it's equally difficult to see why the requirement for likely undue prejudice to the appellant was specifically inserted in subsection B. 3, furthermore, as we saw earlier under section 5.8, the tribunal is specifically empowered in any event to dismiss the appeal where it appears to the tribunal that the appeal is trivial, frivolous, or vexatious. So quite apart from section 54(2), the tribunal in any event has power to weed out the trivial, frivolous, or vexatious claims of busybodies. That being so, why was it necessary for Parliament to enact section 54(2) to regulate the standing of an appellant if its sole purpose was to weed out the claims of busybodies? 4, consideration of the language of section 54(2) in the context of the provisions of the Eluat Act as a whole militate against the notion that 54(2) is solely about weeding out the frivolous claims of busybodies.
The busybody may be raising a perfectly valid point. The point about the busybody being excluded is that it's not for them to do so. It's a completely different thing from the claim being frivolous or vexatious. A frivolous or vexatious claim is a claim that has no merit. But a busybody may want to bring a claim that has a lot of merit, but it's just not for them to bring.
But if you, it depends, of course, what you mean by busybody. But certainly, when you look, for example, at the parliamentary debates and references to busybodies, they tend to be, the term seems to be used in the sense of people who effectively have essentially advanced, frivolous, vexatious claims, rather than people who have no legitimate interest to interfere, but have a good point to make.
Well, let's get on to your 10 points, because you've now got less than 2 minutes before you're eating into your reply time.
Yes. So the 9th point is that, and this is, I think, the point about the precise meaning of undue prejudice. And I think it arises in the context of Eco-Sud's alternative case at paragraph 6.45, where it says that, well, in any event, because it's invested considerable time, effort, and resources in conserving and improving the environment under threat, then it should be considered to be unduly prejudiced by the minister's decision. And we say that argument is wrong for two reasons. First, the requirement in subsection B, as in the constitutional redress scenario, is for undue prejudice to the appellant's personal interests, whether...
But what's wrong with the proposition that everybody has an interest in the environment in which they live, personally?
Because if that were...
And all you need to show is that is the undue, then, is the important point.
Well, I'll come on to the...
Everybody has a personal interest in Mauritius not being degraded if they live there by development that damages the environment.
But if that were the intention of section 54.2, it is very difficult to see why it was necessary to say anything other than any person. Because by definition, any person, indeed, if you combine the point you've just made with section 2, whereby there is this universal duty of care, as it were, towards the environment that's imposed by the Act, it must follow, as night follows day.
You've got the word undue, and so you've got the factor there that you would probably you would require something more than just every person at that point. But that's where an organisation, say, that takes a special interest in the environment may be appropriate, whereas just any citizen may not. But and your argument seems to depend on defining prejudice in a way that only means people's material interests, and not the interests that surely we all enjoy
Are you saying that prejudice applies only to patrimonial interest, yes or no?
Well,
and if no, what else?
I do say that. I do say that because the requirement is that the appellant must be able to show that it suffered undue prejudice. Now, it's very if the only interest sought to be that is intended to be targeted by subsection B is the general interest that...
No, it's still not the only interest, but your argument is that it can't be taken, that only economic interest can be considered. And that is what I'm having great difficulty with.
Well,
in environmental
it may not necessarily be limited to a purely commercial interest, but it has to be a personal interest as opposed to what I call a representative interest. So, for example, whether you put that, whether you draw the distinction between what is representative, a representative interest, which is the form of interest that Eco-Sud has, as opposed to a personal interest, whether you see that as a requirement of the section as a whole, or a requirement that flows from the language of undue, may not matter too much. But what I'm saying here is really this, that it's a distinction between the interest that Eco-Sud promotes on behalf of the public and society at large.
Well, I wonder if Eco-Sud is purporting to represent anyone other than...
Well, it is. If I show you the constitutional rules of Eco-Sud, okay, and I think that's important. If you look at EF page 153, you will see the rules of the association. If I can please ask you to look at Articles 3 and 4 in particular. It's clear from those rules that it is a representative association that exists for the benefit of the public as a whole, and with its membership being open to the public as a whole. And the interests and the objectives, therefore, that it pursues are objectives effectively on behalf of the public and, as it were, society as a whole.
Well, it's on behalf of the environment.
Yes.
In relation to, of course, in relation to the environment.
It's Lord Hope's point, who protects the ospreys?
Well, who speaks for the, yeah.
Who speaks for the ospreys?
Indeed, and indeed, Eco-Sud, amongst others, speaks for the ospreys. But again, I go back to the point. Nobody is suggesting that that in any rational system of law, nobody should be capable of speaking up on behalf of the ospreys. But in the absence of the appellate jurisdiction of the tribunal, those who would have been able to speak on behalf of the ospreys would have been those who would have been able to show sufficient interest to challenge any relevant executive decision that might affect the environment.
So the ospreys are protected by judicial review, but not by an appeal on the merits.
Indeed.
That's your position. Yeah.
That's where it ends. But can I finish?
And are you suggesting that when you say a representative capacity, if we had an individual expressing the same concerns about the environment, would you be saying that that's different or the same?
No, sorry, it would be the same, and this is because I don't address my first reason. The second reason I think will answer Lord Stephen's point as well, I hope. Just so that I can cover the point, and then you can come back to me if I've not covered it. So the two reasons why I give as to why they can't meet the undue prejudice point is, first, because the requirement for undue prejudice in subsection B, we say, is prejudice to the appellant's personal interests, not prejudice to their interests in a representative capacity.
We have that point.
You've got that point. The second point I make is that the requirement under subsection B, moreover, is undue prejudice, not merely prejudice. And we say, as a matter of interpretation, the concept of undue prejudice must be understood as a whole in the sense of prejudice, one which consists of more than the disappointment of one's objections during the consultation process, having been insufficient to persuade the minister to refuse to issue an EIA license, because otherwise, why not give any such person who's participated in the process a right of standing? And two, consists of prejudice that is greater in extent than the general prejudice that may be suffered by members of the public at large as a result of the minister's decision. Only in that sense can the prejudice be undue in relation to the appellant. And so therefore merely, the double problem in my respectful submission that an organisation such as Eco-Sud has in terms of trying to come within section 54.2 is that the prejudice it has suffered is not prejudice to it per se, because it only has a representative existence, only representative objectives by the very nature of the organisation. And secondly, because it isn't undue, because the prejudice that it experiences by the very nature of the organisation that it is only the prejudice that is felt by any member of the public. And that is, in my respectful submission, the short answer to this point. I think if I say anything more on the point, I'll probably just repeat myself, but perhaps I can finish with the relevance of section 2, the Universal Declaration.
Well, I think you said you're at 10 points, and this is point 9, the precise meaning.
The point 9 was the point about prejudice.
Yes, and point 10.
Point 10 is about section 2.
Oh, point 10 is section 2.
Yes, forgive me. So section 2, the new section 54.2 was introduced by section 8 of the Eluat Act with effect from October 2012. So that's some 10 years after section 2 was enacted as part of the EPA. It's very difficult to see how the general language of section 2 can actually assist in ascertaining the true meaning and intent of section 54.2, which was specifically about the scope of the appellate jurisdiction of the tribunal and the test for standing before it. Secondly, Eco-Sud's reasoning at paragraph 6.18 of its written case, and it's quite instructive, page 1542, if you look at that, its reasoning is that the obligation imposed on every citizen of Mauritius by Section 2 must extend to participation in the statutory processes intended to protect and preserve the natural environment of Mauritius, including the protective regime relating to EIAs. But even if this were correct, as we've already pointed out, the right of appeal under Section 54(2) has decidedly not been generally extended to any member of the public who happens to participate in the public consultation process. Instead, notwithstanding the broad public consultation process that we've already looked at, the right of appeal is restricted in the way that it is. The third point, perhaps I'll skip the third point because it's based on what one can infer from the 2020 amendment, which we know is post the relevant date. So those are my main submissions, and the final remark I make is in relation to the Sauvage case. I don't need to take you to the Sauvage case, which was decided by the Mauritian Supreme Court. The key passages in relation to Sauvage are set out at paragraph 37 of PDC's written case. That's pages 1568 to 1572. The Supreme Court's reasoning in Sauvage is materially different from that of the judgment under appeal in this case. So there has been a divergence at Mauritian Supreme Court level in relation to the proper construction of Section 54(2). And the reasoning in Sauvage, the reasoning on statutory interpretation, is more in line with our arguments on this appeal, in particular in terms of emphasizing the need for proof of undue prejudice to the appellant. The result in Sauvage, however, was slightly odd in that the Supreme Court nevertheless allowed the appeal to the extent of remitting the matter to the tribunal. But it's very clear from the passage that appears at the top of page 1572 of PDC's written case, quoting from the judgment, it's very clear that the reason why the Supreme Court remitted the matter to the tribunal was because it considered that the tribunal had wrongly limited itself to consideration of whether the appellants were aggrieved persons and had failed to consider the undue prejudice element in subsection B, which in the Supreme Court's judgment required specific consideration by the tribunal. So, my lords, my lady, unless I have you have any further questions, those are my submissions for now.
Can I just ask a quick question? What is the costs regime before the tribunal? If you challenge the grant of a licence and you lose, are you at risk as to costs, or is it no costs?
There are costs provisions. What I don't know is what they say specifically as regards quantum. So if we look at the Eluat Act, which introduced, forgive me, so if we go to EF 1660, and in particular, forgive me, 1664, you can see the order for costs. Oh, yes. You can see that, 1666, at subsection 10A, the tribunal may make such order, towards the middle of the page on 1666, the tribunal may make such order as it thinks fit as to the costs payable by the losing party. and then B as well, an order made under paragraph A may be enforced by the other party in the same manner.
So if you go for a merits appeal, you may find yourself, if you lose, facing a costs bill. Yeah.
Indeed, yes.
Thank you. Thank you very much.
Yes, I'm told the costs in Mauritius are much lower than over here and tend to be.
Well, that's a good thing.
I don't know any different from what I'm told. So
you mean the cost awarded, not the cost charged?
Both.
Perhaps both. I rather got the sense that it was both, but perhaps I'm wrong.
Thank you very much.
Thank you.
My lords, milady, I can confirm that the costs generally in Mauritius are ridiculously low. And that certainly is not certainly a deterrent to anybody to litigate. So on behalf of Point Estime, my lords, milady, and alongside my friend Angélique Devolu-Marini, I'll have to speak louder.
Yeah, louder. Move over a little bit more.
All right, thank you. Here?
I think it was a better choice here.
Sorry. So, my lord, sorry, I'm losing a lot of my precious time. I've been allocated 20 minutes, and I'll try to go at a pace rather fast, just to be able to address on the points that have already been suggested by my learned friend for the appellants within this time frame of 20 minutes. And my learned friend Devo will, at the end of the day, if ever there's any need, make a reply this afternoon.
Well, there's not much reply time left.
Oh, I see.
Never mind, on you go.
Unless you want to save any of your time from now to reply.
I'll go very quickly, and if I'm too fast, I beg to be excused. So, as you know, PDC supports the appeal. You might think that there's indeed not much to add in support after this very, very comprehensive address of my learned friend for the appellants, and you'll be right. Globally, I'm essentially in agreement with what he said this morning, and I'll try my best not to be at all repetitive. Nevertheless, I shall not only address the issues he has suggested, but also I'll try to touch upon, and very briefly, some of the issues that have been raised by Eco-Sud in their supplementary case of last week. So the first point is the appropriateness of Hansard, and then there are the other related issues under Section 7 of a written case, always speaking international obligations, Climate Changes Act. And it's only thereafter that I shall come to the two issues elaborated by Eco-Sud in the supplementary case, that is unjustified dichotomy and public interest litigation. And I might make, if I have some time, a concluding remark. Hansard, I think quite simple. The law allowing resort to parliamentary debate is quite settled in Mauritius. Hansard should only, and I think one of your lordship made this observation this morning, should only be referred to interpret a statutory provision when that provision is either ambiguous, self-contradictory, or yielding an absurdity when applied. The case laws, Mauritian case laws, we are all familiar with it, and one of them is from the board. The case of Lamus Sexum, 2012, that is being referred to at page 2315. And Lamus Sexums also cites Globe Prism, Madeleine Clothing, and others, and I need not go because we are all quite, we appreciate the reference and the fact that it is quite a settled rule. The issue, therefore, is not the principle, but the application of the principle. And our contention on behalf of PDC is that there is no ambiguity or self-contradiction or absurdity which permits reference to the parliamentary debate. On the other hand, Eco-Sud advocates that there is ambiguity and that this ambiguity springs from the different interpretation of the word aggrieved person, Why I say that is that I would like to refer your lordships and your ladyship to Eco-Sud's written submission, which is on record before the Supreme Court, and more particularly under paragraph 4.7, page 1384. And I read very quickly through it, and this is what they wrote. In the light of a wide range of interpretation that has been given by English and Australian courts, this was the statement in writing of my learned friend appearing before the Supreme Court. So in the light of the wide range of interpretation that have been given by English and Australian courts to the term aggrieved person and similar phrases and the lack of clarity on the same in our Eluard decision, it is submitted that the search for the true intent, meaning, and spirit of 54.2 must be carried out through a reference to the Hansard record on parliamentary debates. In its written submissions, Eco-Sud cites and annexes extracts of the 2002 parliamentary debates and invites the court to rely on them to interpret a test which came to life, my lords, milady, 10 years later, in 2012, section 54.2. And more particularly, you will referring to the paragraph 4.56 of that written submission, and also and the 4.59. And the concluding remark on what was made then is that the legislator cannot have intended to import an interpretation to section 54.2 incompatible to the objective of the Convention on Biodiversity. That was, in fact, she was referring to the 2002 Act. However, as I just said, the test in 2012 is drastically different from that initial test. In 2002, as my learned friend said this morning, the tribunal could hear any decision of the minister on an EIA, whereas in 2012, access to the tribunal is allowed. We know the two limbs quite well and need not to repeat them. The 2012 amendment, therefore, to section 54 was brought, and it's quite telling, and it was brought about by section 8 of the Eluard Act. So therefore, the parliamentary debate in respect of these amendments of 2012 are of interest. And they were placed before the Supreme Court by myself on behalf of PDC during oral submissions offered in 2022. And that was in reaction to the 2002 debate previously ushered in by Eco-Sud. The proposition of Eco-Sud then was, in our oral submission, my learned friend Julien said, it is not a legislation that is intended to restrict access to justice. And if that was the intention, then in my submission this would have been addressed in the parliamentary debates, because there were lengthy submissions by Parliament in 2002, but we were in 2012. And that this particular reference is at page 1430, line 21. Additionally, in the written submission of the minister, appellant, ministry, the appellants today, the attention of the court is drawn to salient extracts of the 2012 parliamentary debates, which focus on the need to improve the efficiency of the tribunal and protect the environment while ensuring the sustainable economic growth of our insular country. In that written submissions, the ministry had put a lot of emphasis and had underlined different important parts. That is at page 1404 and 1405. Yet the Supreme Court, first of all, does not consider the deliberate intention of the legislator to curtail access to Eluard. That was the intention, and it's quite clear, and makes no reference to the salient parts of the debates that had been underlined by the ministry. But instead, it relies on the generic, non-specific part thereof, which do not help in grasping the true intent of a legislator behind the important amendment of the provisions of to section 54.2. These amendments, the drive, in fact, if you look at it all, and these parliamentary debates, the drive behind is to boost, to sustain economic growth and stimulate investment. And here we can have all these extracts at 1405 of the I think 1405, I can have it, but these parts were reproduced in the judgment. And I can...
Is there any other amendment that was made in 2012 that you can point to, an amendment to the EPA Act, which furthered that, boosting economic growth and boosting investment? Because I think there were other amendments made to the text of the EPA in 2012, weren't there?
Yes, there were, but now I was trying to see reference to Hansard and the parliamentary debate, and to what was the spirit behind these amendments, curtailing the access.
Sorry, the board, I think, will gain very little assistance from the parliamentary debates. So in the short time you have, you should concentrate, I think, on other points. At the end of the day, our task is to interpret the meaning of undue prejudice as an additional requirement in subsection B.
I fully appreciate. But just to end in a nutshell, the Supreme Court, in my humble view, failed to consider the new statutory gateway to the tribunal in the light of the debates. But my learned friend has already expatiated quite lengthily on these the interpretation and constructions to be given to 54.2.
I will be saying exactly the same to the respondent. That
yes.
The board is very unlikely to gain any real assistance from the parliamentary debates. The fact that there has been an additional requirement indicates an intention to impose a restriction. The question is, what is the meaning of that restriction?
I do not have. I do not want to repeat, and because it was so well stated by my learned friend, and I think following all the questioning and the observations made by your lordship, by the board this morning, he answered it quite well, and I entirely, as I say, I'm in agreement with what he said. In fact, what my task was this morning, it appears, as the plan had been suggested by my learned friend, is to go very quickly and understand to answer, and then to go to the other related issues, which have been touched upon by Section 7, under Section 7.
Well, the board would be interested to know what other amendments were made in 2012. There was a mention earlier this morning of the time limits being tightened up.
Yes.
And that obviously is part of the parliamentary context.
Exactly.
And we would be interested in that. And the board is also interested to know what is the test for standing under the 2004 Act as amended. That's the Planning and Development Act.
On the question of the time frame being reduced, this from 30 days, by the way, to 21 days for the appeal to be able to be done to the tribunal, which also was a clear pointer to the fact that they wanted to expedite matters and therefore to be able to stimulate investment and not to be...
Yes, if a note could be produced of the provisions that restrict the time
yes,
limits,
I shall do that.
Then that point...
I think that was an amendment in 2018 by a particular act of 2018, but I will gladly favour...
So not by the 2012 legislation?
Yeah.
Well, maybe.
Yes, but no, it was 30 days. Any person could, and then it was restricted that the statement, that the challenge had to be within the 21 days frame, and it was reduced. So curtailing, I mean, the indication was that they wanted it to be expedited. They didn't want to have. To have litigations around the tribunal that would last too long. And there's something else they brought in, I remember now, that once you start the hearing, you've got 3 months to complete it. So you could not, because in Mauritius we know things drag on quite a lot, and they said, point A, you start the hearing, and then you've got 3 months. The tribunal's got 3 months to complete. This also is an element in the time frame that might be of interest and of concern to all of us to show where the Parliament was leading us to. But I will I will find it out during...
What happens if you don't complete it within 3 months?
Big question. I mean, I think... Huh? Yes, a globe prism emphasizes this question, maybe my learned junior tells me. But I think that the parties could, am I right? The parties could agree in special circumstances that it be extended. This is, but it all shows that it has to be done quite diligently. The issues about the related issues that were, I think they are quite simple. The issues were not raised, but first of all, I like to say these other related issues that was been headed, related issues under Section 7 of the written case of Eco-Sud. They were not addressed before the Supreme Court. They were not raised by the appellant. They were not addressed before the Supreme Court to attain the judgment we are challenging today, the impugned judgment. And strictly speaking, in my humble view, may I say that they do not really constitute live issues that should deserve consideration by the board. And in fact, I see it personally that this is an attempt by the respondent to canvass issues anew in an attempt to defend the ultimate conclusion of the Supreme Court. But anyway, I'll have a few words to say about it, if that might be of some interest. First of all, always speaking, we do not dispute that the law is always speaking. Referring to the written submissions of Eco-Sud before the Supreme Court, we understand their submission to be that Section 54.2 must be interpreted with the benefit of case law acquired until today. This broad proposition is equally not disputed. However, this principle, that is always speaking, is of little use in the context like the present case. Why? Because there is no precedent post-dating the 2012 EPA amendment that has placed before the court the notion of undue prejudice to him. So, I mean, I don't think the reference always speaking rule is of any relevance to this morning to our case. Then the second point is about international obligation. Eco-Sud submits that Section 54.2 must be interpreted in a way consistent with the international obligations of Mauritius, at page 1551 and following. We note that Eco-Sud concedes that the Convention of Biodiversity, this is in paragraph 7.5 of a written case, at page 1553 of the bundle. We note that Eco-Sud concedes that the Convention of Biodiversity is not directly applicable in Mauritius for lack of domestication, or in other words, for a lack of transformation. We note also that Eco-Sud suggests that the courts are entitled to interpret 54.2 in the light of the intention of Mauritius, which has signed the Rio Convention, which moved towards better access to justice in environmental matters. But to this we wish to say, on the one hand, that there is still access to the tribunal in the way that they have to show undue prejudice to them. And on the other hand, and my learned friend has elaborated quite lengthily on it, there is also the other recourse by way of judicial review. And at the end of the day, it is the sovereign parliament of Mauritius that has devised this law, and that therefore I believe that we should agree that until and unless it is declared unconstitutional, it should be applied. I can make a quick reference here to the case of Nick.
As far as international obligations are concerned, the one that's quoted is Article 14.1, which leaves it up to the contracting state to determine what is appropriate to allow for public participation in procedures. And so for my own part, I don't get much assistance from the suggestion that the legislation, Section 54, should be interpreted in accordance with international law.
Yes. So, on this point, maybe it is of interest to refer to a case that has been put on record at page 2185, Nick columna. It is a local case of the Supreme Court, 2185, Nick M. columna, 1988, where, and I read, where the text of a local law is ambiguous and capable of being interpreted in more than one way, the interpretation which brings it in line with our obligation at international law should be preferred to one which brings it in conflict with such obligation. Then they go on.
Which paragraph are you reading?
Paragraph.
You've told us the page number, which is the first page.
Yes.
Yes. It is the last paragraph of page 2193.
Thank you.
The penalty limit one. They made reference to Halsbury. But then it continues. If, however, that's the following page, 2194, if, however, an enactment is clear in meaning, it must be construed according to that meaning, even if this is contrary to the Committee of Nations and international law, and whatever the effects upon the rights of aliens may be. So it's all a question whether the meaning is clear and plain, and we have all throughout stated that the meaning is crystal clear. The next, I don't know how much time have got left. The next point is about Climate Changes Act, which was one of the related issues, the third related issue that was set out under Section 7. Climate Changes Act came, this is the point I like to make about it, it's a question of chronology and intention. Climate Changes Act 11 in 2020. So by the Finance Miscellaneous Provision Act 7 of 20, it amended 54.2 by introducing this third limb. You will remember the Statement of Concern limb. Okay, so the Climate Changes Act was in fact posterior to that because it was an Act 11. So the one that amended was the Act 7, and then there was a Climate Change Act 11 of the same year. And of interest, this Climate Changes Act brought quite a substantial number of amendments to the EPA, to the Environment Protection Act, under Section 30. Section 30, the consequential amendments. There was Section 3, 11, 16, 18, 24, and a great number, and many more were amended. And yet, my point here is that yet the legislature did not deem it necessary to amend Section 54.2. That is, the jurisdictional section that gives access to the tribunal. And I think that is very revealing. Had it been the intention, they would have. And this is the more so important because in the court below, and this is where as far as my memory serves me right, my learned friend Anne-Sophie Julien, when she was submitting before the Supreme Court, she said that Elliott has taken a consistent restrictive approach denying standing, hence accessibility, to appellants who cannot show that they have been affected by the project. So the point I'm trying to make is, and she made reference to a few cases. May I refer your lordships and ladyship to page of 1390 and 25. And this, the remark she makes, I think it has page 1432. So she cited 3 cases.
So which page are you wanting us to look at?
1432.
1432. Thank you.
1432. So a reference was made here to 3 names, 3 cases. One which is written below, but I'm not quite sure it's well written, but this is how it is recorded. Then Agir pour l'environnement and David Sauvage. I really do not know what the first case is all about or what is the real name, but what I know is that the last 2 cases are 2019 cases. That is cases prior to the Climate Change Act. And why I say they are, David Sauvage, we have been referred to it, and reading the judgment of the Court of Appeal, we know that it was the ruling of the tribunal was in 2019, and in relation to AG pour l'environnement, which also has been delivered in 2019, this can be seen at page 1390. So the conclusive remark I'd like to make on this, that in spite of Eluat consistently rejecting appeals to it on the basis that the appellants did not meet the statutory test of 54.2, the legislator has not amended the law to adopt a more liberal approach. These are the 3 points I wanted to touch. Now I'll go very, very quickly, if I'm maybe allowed, on the supplemental case.
Very briefly.
Very briefly.
2 minutes.
They entitled it unjustified dichotomy. Okay, the Palestinians' contention here is that the Supreme Court has denaturated the legal criteria in 54.2 and created an unjustified difference between individual and organization. And this point has been made by us in our written case on the ground B of the appeal. The ground B impugns the interpretation given to 54.2. We support that ground. The Supreme Court, what I want to say, specifically mentioned an appellant organization. It could easily have written any person, but it does not. The court states that an organization who have standing under 54.2 if it is generally acting in the general interest. So, according to the court, one would have standing if he demonstrates a genuine concern and interest in environmental matters. The Supreme Court proposition is couched in very broad terms and refers strictly to an appellant organization. Okay? and then they mix it up with physical persons. So in paragraph 2.2 of this supplementary written case, Eco-Sud is inviting the board to save the test, in fact, devised by the Supreme Court by ignoring the specific reference to the appellant organization, and they try to extend it to physical person as well. In my humble view, this is a rewriting exercise. And in fact, if we were minded to accede to such creative rewriting exercise of a judgment, it is BDS proposition that the new test propounded by the Supreme Court in Eco-Sud is still grossly flawed because the Supreme Court has brushed aside the two fundamental components of 54.2b of the statutory test, undue prejudice, personal prejudice. These two notions are missing. The reading of 54.2 test appears acceptable after all by Eco-Sud, and this is interesting. This reading of 54.2, there is contradiction. When it writes, persons who do not have personal standing may be granted standing to appeal a decision of a minister on the ground that they are acting in the public interest and that they are justified in acting in a representative capacity. Therefore, according to the above statement, what I make of it is that a person who has no personal standing may be granted standing because they are acting in the public interest in a representative capacity. And that brings us to the last point of the public interest litigation. In paragraph 3.1 of its supplemental case, Eco-Sud disputes the proposition that the judgment introduced a form of public interest litigation, PIL. In particular, Eco-Sud disputes the proposition that PIL is not permitted under Mauritian law. However, this proposition is accepted by the Supreme Court itself, and this I'm not going to read it, but it's at page 1465, where they acknowledge that there is a ban on PIL in Mauritius. But then they say that we are in presence of a statutory appeal before the ELUAT against the decision of the minister to grant an AI license.
What is your point in a nutshell?
My point is that the Supreme Court, there is a ban on public interest litigation in Mauritius, and I find it extremely strange that the Supreme Court would say, okay, this is left to a common law court and should not be a rule, this ban, to be followed by a statutory tribunal.
So Eco-Sud couldn't bring a judicial review. If they can't appeal, they can't bring a judicial review because they'd be pursuing a public interest. Is that right? Is that the case you're making?
even for a judicial review, public interest litigation is not allowed.
So if they don't get the appeal, they do not have standing to bring a judicial review because they'd be acting in the public interest. Is that right?
No, in a judicial review, they only have to satisfy the test of sufficiency of interest, which is totally different. But what is not allowed is for them to bring in a public interest litigation in a representative capacity.
Well, do you accept that they would have standing to bring judicial review proceedings?
Yes.
So do you accept that they do have standing to bring judicial review?
I think if we look at the evolution of the law,
I mean,
It's a yes or no, and I think you're being prompted to say yes.
if we look at the evolution of the case law, AXA, the last case of Mussington, the case of Mussington also, yes, there has been a universal evolution in relation to allow, but these are in the GR context.
That's an unequivocal yes, they do.
Yes.
So what you're saying is that the ban, supposedly, on public interest litigation in Mauritius would not preclude a Mauritian court from taking into account the AXA and Walton decisions of the English court. You accept that?
Yes.
Well, at that point, your submissions must conclude. Thank you very much. The board will now adjourn and resume at 2 o'clock when we will hear from the respondent.